Cheryl Perich was an elementary school teacher at Hosanna-Tabor Lutheran Evangelical School and Church. She was not just a teacher, but a commissioned minister, which was a formal rank within the church. In June 2004, Cheryl Perich collapsed on a school field trip and was diagnosed with narcolepsy. The school tried hard to hold her job open in her absence, but eventually they had to hire a new teacher for her classroom. And so when Perich said that her doctor had cleared her to return to work, the school didn't have an opening for her, and they proposed that they work on doing something about that in the next fall. So that was not a termination. Perich threatened to sue the church, and in response, the church fired her and revoked her call as a commissioned minister, and she sued them for retaliation. Perich and the Equal Employment Opportunity Commission sued under the Americans with Disabilities Act, which includes a provision that if you complain about an allegation of disability discrimination, the employer cannot retaliate. This was clearly an instance of retaliation. You can't fire somebody for threatening to file a lawsuit, and the church never disputed that. The question was whether this act, which would otherwise have been illegal, was protected by the ministerial exception, the rule that ministers can't sue their churches. There were two issues before the court. Is there any special rule about ministers suing their churches over employment matters? And if there is Cheryl Perich a minister under that rule? Hosanna-Tabor argued that the First Amendment includes a ministerial exception. The lower courts have been unanimous about that for 40 years, and there were good reasons for that unanimity. A church has to be able to control the people who speak in its name, and civil courts are incompetent to adjudicate how good a minister somebody is. And then on the second question, was she a minister? The church said, well, look, she's got a formal rank within the church. She plans and leads worship services. She leads prayer. She teaches the faith to the children. It doesn't matter that she also teaches math and reading. These religious functions make her a minister. The EEOC and Cheryl Perich argued that there should not be a ministerial exception. Back in 1990, the Supreme Court had rendered a decision about religious use of peyote. And they said, if the law is neutral and generally applicable, then the Free Exercise Clause does not create any religious exceptions. And basically, the EEOC thought that that decision wiped out the ministerial exception. But if there were a ministerial exception, Perich was not a minister because she's mostly just a teacher. The opinion by Chief Justice Roberts was fairly straightforward. The court reaffirmed the ministerial exception and agreed with the courts of appeals over the preceding 40 years that a church has to be able to maintain control over the people who speak in its name. Employment Division v. Smith just doesn't apply to these internal decisions that affect the faith and doctrine of the church itself. As to whether Cheryl Perich qualified as a minister, Roberts said, we can't draw clear boundaries or decide exactly who is and who isn't a minister, but Perich clearly is a minister. She has important religious functions. She had to get important religious training. She has a ministerial title. She held herself out as a minister when she had the job. She clearly falls within the ministerial exception, and she cannot sue.